You want to post, well, I feel bad, there's people out there who want to watch or, hopefully we'll just keep the noise down out there.
They could stand there.
You want to stand in here, stand by this door, come on in and stand over here. Yeah, come on in. We'll leave that door open. Yeah, gentlemen. Well, welcome everybody. This is quite the turnout. This is my very first hearing, so I'm learning lessons. I think if I realized how many we're going to have, there's a bigger space downstairs, I probably would have booked. So I apologize for packing everybody in unexpectedly, having such a fantastic turnout, but a big turnout. I would like to start by welcoming our nominee, Attorney Tracy Duncan, nominee for Massachusetts Superior Court today. Welcome to council. I'm going to start off introducing myself and my fellow members of council. I'm Tara Jacobs. I represent District 8, which is all of Western Mass and a little bit of Worcester County. And to my right, I have Councilor Ferrara, Councilor Devaney, Councilor Ianella.
Good afternoon.
Good afternoon.
Councilor Duff, Councilor Kennedy, and Councilor DiPaolo. I'm going to start by reading into record the nomination letter from the governor, dated October 4th, 2023, to the Executive Council. Dear councilors, I am pleased to nominate Tracy E. Duncan to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy. Before we get started with witnesses, I wanted to give you the opportunity to share with us, introduce any family and friends in the room today.
My age. Present with me, my mother, most importantly, Betty Davis.
Welcome.
I have Attorney Jim Goodhines, who's one of my speakers. Here, boyfriend Dennis, Carla Tucker Kennard, Jackie Lee Washington, the Honorable Retired Justice Tina Page, my niece Bria Earl, oh my goodness, Lisa Mungeon, who's like my godchild. You all know Representative Williams, Cliff Flint, a longtime family friend, my nephew Raymond, my 45-year best friend, Muriel Steptoe, my sister, Deborah Duncan, my good friend Julie Akers, and next, Attorney Clarissa Wright from the ADA's office, the DA's office, and my boyfriend Charles Richardson. I think that's everyone.
Welcome to everyone. Let's start. We have the first witness for you today is State Representative Bud L. Williams. If you want to come over here, you can stand or you can sit next to Tracy, however you feel most comfortable.
Thank you.
Excuse me.
It's a tight room.
So used to that room downstairs.
I forgot to introduce Judge Sweeney right here.
And Judge,
Here, Judge Sweeney.
Good afternoon, Honorable Chairwoman, members of this very distinguished council, and thank you folks who, what you do day in and day out. Doesn't go unnoticed. I have a letter that I've given to Chairwoman that you can circulate members of this very distinguished body. I have a very unique perspective of this nominee. I've actually worked with her many years. As most of you know, I'm a retired probation officer, spent 32 years in trial court, Springfield. I have the distinct pleasure of working with Judge Page and Judge Sweeney. Feel like I'm back at work. You won't find a more qualified and better person than Attorney Tracy Duncan. I've worked with her from the probation perspective, worked in the trial court, I worked in pretrial conference, I've worked six-man jury. I've done violations with her, had to put some people away. She's always demonstrated impeccable knowledge of the law, impeccable knowledge of being a justice in dispensing justice, fair and balanced. And you can always say she fights for what she believes in. Fought for many individuals in that courtroom, many who were really poor, down in their luck. But she always fought very, very hard. Impeccable integrity. And me and her have gone at it. She'd come in my office, we talked, she's fighting for her. I had to do what I had to do, she had to do what she had to do. But you won't find a better individual. And I have worked with many judges, I know judges. I'm not new at this. I go way back, my first judge was Judge Sloan and Judge McGannis, Judge Sheehy, I can Judge Boyle, Judge Coomer, Judge Tian, I can just Judge Beatty, I can just go rattle, rattle, rattle. That district court had a unique, and Superior Court, had a unique perspective of judges. Really great judges in that courtroom, really, really great judges. And I think she fits that mold. And this will be the first time since Judge Tina Page has retired that we'd have an African-American woman for Superior Court. So I want to commend Governor Healy. As I made the recommendation to Governor Healy, we put her on the bench. She heard my cry, and the rest is going to be history. So I really feel that this is a great choice. As I said, I have a unique perspective and many, many things. And the last thing I'm going to say, I would always, when you in the courtroom and you leave, you go home, you go to work. I would see her, she'd be walking back to her office and we'd cross paths. Always a lady, and always cordial. And the way you see her demeanor now, I've never seen Attorney Tracy Duncan get upset. Never have seen her get upset, have an outburst. We all have outbursts. I have an outburst. She's always cool, calm, and that demeanor is what we need, especially Superior Court. And the backlog is tremendous in Superior Court. But that demeanor we need, people who look out and dispense justice the way it should be dispensed and balance the scales of justice. And she will be fair, she will be balanced, but at the end of the day, she's going to make the right decision. She's going to make the decision that should have been made. As I said, you won't find a better candidate than Attorney Tracy Duncan. And I stand with her, and hopefully this very distinguished body will do the right thing. So thank you, and thank you, the newest member of this body, for the hard work that you have been doing. And sorry for your loss too. Sorry for your loss.
Thank you so much. Does anyone have any questions?
Okay. Thank you for coming in, Representative. I can see, given the manner in which you gave that speech, how you got elected so easily. Let your colleagues know that we do a lot of work up here. Thank you.
Justice Kennedy, now you folks, you really do. People, and I don't want to just start talking about the governor's council. You know, once a week, come to the building. You have other individual jobs you have to do, but you come in here and you do the best you can do.
I can tell you, Representative, it's a lot more than once a week for everybody.
I mean, you know that.
We're in here once a week, but it's a lot more than once a week in terms of what we do. It's a lot of work.
I'm going down to vote, and I will deliver that message to the speaker with pleasure and honor. And I really mean that. So thank you, folks. Thank you.
Councilor Duff, did you have a question?
And I don't, thank you.
And Councilor Devaney? Yes, I'm calling, yes.
Thank you for your very heartfelt talk. I was going to ask you, what attribute do you think this nominee, the greatest attribute she has that she brings to the bench?
You know, there's many. I thought about that last night. I thought someone would ask that question. I really did. I think, from my, not only, she really cares. She really cares and cares about the community, no matter what age, color, what gender, she's gonna care. She's gonna bring that passion to the bench that I remember Judge Sweeney and Judge Tina Page had. This passion for, but you know, at the end of the day, it's a tough job because sometimes you're in Superior Court. You're giving out time. I mean, you're giving out real time. But I think she's gonna care. It's gonna be a balance. It's gonna be a fair decision at the end of the day. And it won't be political. It won't be status quo. She won't put a finger up and see which way the wind is blowing. She's gonna make a decision and she's gonna stand by the decision. I just think one of her greatest attributes is that she really cares. She cares about mankind, human mankind. I
And
really,
that is the greatest, yeah.
that's, yeah.
And I want to thank you for all your service.
Thank you. I remember your cousin Danucci. Sound like Kennedy. I go back a little ways here. We're. Kennedy can't, yeah, he heard.
All right, huh? Yeah, see? You say nice things about me, I'll come closer.
Former artist of Danucci, and I said, we go back, and I said, well, Kennedy, we go back, way back, so we've been on the battlefield.
My cousin, Joe was my cousin, Joe Danucci. He was the auditor for 30 years, and I was quite proud of him. We miss him. We miss him.
Kennedy has that great name, you know.
Any other counselors have questions? Okay, thank you so much. Thank you for offering. Our next witness here today is the Honorable Constance Sweeney, retired Associate Justice of Superior Court.
It's all right if I. Thank you. I'm used to the record. So for the record, my name is Constance Sweeney, retired judge of the Superior Court. I've served on the court for 34 years before my retirement. Through part of that time, because he's a good deal younger than I, Attorney Duncan appeared in front of me in the criminal sessions constantly. And there's no way to put it, constantly. She is a wonderful lawyer, and that will translate to the bench. She is deeply entrenched in the law, and particularly in the criminal area, which in Western Massachusetts, particularly the greater Springfield metro area, is critical because of the tremendous caseload that goes through our courts in that area. Regardless of the caseload, you have to treat every person who comes before you with dignity and respect and interest in what their position is. She is a quintessential, and I stress that, the quintessential judge in terms of demeanor, in terms of loyalty to her client without overstepping ever ethical boundaries. I will be very glad to answer any questions you have about her.
Counselor Devaney.
Nice to see you, Judge. I hope you're enjoying your retirement.
I am indeed.
That's great. Well, you've earned it. Let me ask you, she has come before you. Okay. Can you think of one case that stands out that you were so impressed with her?
You know, I'm not, thank you for that question. It's going to pick the most complicated or this case for a particular reason. We had in Western Massachusetts, and particularly in Hampden County Superior Court, which covers everywhere up until Northampton, west and north after that are Berkshire, Hampshire, and Franklin. That said, we had a very difficult period, now going back some time ago, where there was, and even today there remains inadequate numbers of attorneys who are willing or able, because of their caseload, to handle indigent criminal defendant cases. And it got to a critical mass. At the time, I was acting as regional administrative judge, and like it or not, it came to me to sort it out, which I did rather clumsily, but nonetheless. In any event, in this amazing skirmish, defendants were getting lost in the fight, so to speak. They were getting lost because of the tension between the DA trying to get paid through, the defense bar trying to catch their breath to represent clients and having to turn down clients. And the two met before the court, and all the issues and some very strict orders, and I'll take account for those. Very strict orders had to issue in order to give proper representation to the individuals who are appearing before us. Attorney Duncan was at the forefront of trying to resolve the issue in terms of recruiting attorneys, because we had to reach out beyond the normal criminal bar. Yes, to criminally experienced lawyers without question, but we had them from Worcester. Some came as far as from Eastern Massachusetts on a regular basis. Berkshire and Hampshire helped us out. She was at the forefront of that coordination, and at the same time representing client after client until she had to say, properly so, have to stop right now, my load is going to tip and I can't properly represent them if I go more than that. But she stayed with it all the way. It was a dedication to justice. It was a dedication to the individuals who come before the court. And that is what sticks out in my mind the most. Yeah, I could talk about a bunch of cases, from murder to the most pedestrian type of case. And I would have much the same thing to say. But in terms of the dedication to justice, she was a hallmark of it during that period of time. And amongst the bar, she has remained so. And amongst our judiciary out there, she has remained so as well.
Thank you, Judge. Your testimony means so much to me. And I have to say, in my 25 years, I have people that were sitting in that chair, and I'd ask, well, what experience have you had with this nominee? How many cases have you seen? One. Give me a break. So, I mean, it's heartfelt, it's personal, it's professional, and it means a lot to us. Thank you so much.
Thank you. Counselor Duff.
Thank you. Thanks, Judge, for being here to see us today. We appreciate it. There's a little bit of an elephant in the room. Is you wrote, I don't know what it would be called, a decision.
Commonwealth versus Graham.
Thank you. You know exactly what I'm talking about.
Yes, I do.
Can you explain why you did that? And because what it said was that she was ineffective counsel.
That was my ruling.
Okay, and so if she was ineffective counsel, why should we make her a judge?
Absolutely.
And no one better to answer this and get this solved than you. That's why I'm asking, because I wasn't able to hold you before.
More than happy to address it, and I will and continue my remarks and get to the heart of what the issue was. But I will predicate that by saying, and not as an excuse, but any deeply experienced and high volume, especially with indigent defendant cases, sometimes things slip. And that's exactly what happened here. Sometimes it slips with me, and it certainly has. You can read in the mass reports, whether from the appeals court or the Supreme Judicial Court, where I have been brought to task over my years. It happens, and I thank God there is a catch for it, that there's someone who's going to look at it, whether it's a trial court or, in my view, an appellate court. So I leave that as a foundation. But to the Graham case in particular, my ruling speaks for itself. I conducted hearings on evidentiary hearings on the petition for a motion for new trial for Mr. Graham, and I granted that motion for new trial, and I stated my reasons therefore. In that case, and it was an exception by far, but in that case, there was a failure with respect to adequate representation, but it was not without reason, as it turns out. And I will explain that very quickly and answer any questions for more detail, but I recognize your time frame here. I think, and I'll have Attorney Duncan speak for herself, because Attorney Duncan didn't come into my courtroom and say, stop, stop, listen to me, my heart was in it. She let that process, and this is who she is. She let that process take care of itself because it was her former client who was at risk. And she was not going to try and counterbalance that risk by coming in and making serving statements. That is. Now, with respect to Mr. Graham, and the facts are laid out in the decision, and I won't detail them for you, the facts as I found them. But what this came down to, the core of what this came down to, is that Attorney Duncan relied, and so many defense counsel with crushing schedules, and it was at the time, no question, has to rely on their relationship with the district attorney's office. And by that, I don't mean to make a deal. I mean because the district attorney has an absolute constitutional obligation to turn over exculpatory, helpful information to the defendant. Here, there was a piece of evidence which if it had come in, could well have impacted the jury, and in non-legal terms, that's really what it comes down to. It could have made a difference, reasonably it could have made a difference, and that's basically what I found in that case. But what did not come into evidence, and I only found out later when their Commonwealth versus Graham, and now Christopher Graham versus the district attorney's office, currently under advisement by the Supreme Judicial Court. And I listened to the arguments, by the way, online. It turns out that the district attorney's office, although they have a constitutional obligation to turn over exculpatory information that is materially helpful to a defendant, did not provide, now they had a reason for it, which I'll get to in 1 second, did not provide the piece of evidence on which my entire decision turned. And that is, it turns out well after the fact, and now it's one of the little ingredients, many ingredients that's before the Supreme Court for their consideration, the Supreme Judicial Court. It turns out that the district attorney's office did not view, according to their, what I have read in the record before the SJC, that the district attorney's office did not consider 911 messages or reports part of their constitutional duty to provide exculpatory information to defense counsel. In this case, it was critical because 911 tape would have revealed, and by the way, I don't know why they don't. So there might be good reason. I listened to the SJC argument. I still don't understand the reason. But that said, the 911 tape revealed an eyewitness to this melee in the parking lot of a bar, an after-hours melee in a parking lot. And it turns out that a retired officer of a police department had come out of the bar. He was not on duty in any way, shape, or form. And a eyewitness reported through 911 that, I only found out after the fact, did I think Attorney Duncan reported that he had seen this very bad bar fight go down, and he had seen the person who had pulled the gun. Fortunately, no one was wounded in this incident, all right? That he had witnessed the person who had pulled a gun. And that's where this case turned on, as far as Mr. Graham was concerned. And the person who pulled the gun was a retired officer. And I take it from there. That's all I can tell you at that point. It now turns out, and I don't want to use too much of your time, it now turns out that that 911 decision not to turn over tapes as part of automatic discovery is a significant issue in an appeal before it's not an appeal, it went up by way of certiorari to the SJC. And they took along with many other cases coming out of that same jurisdiction. And as I said, argument has just occurred. And it turns out there were other aspects of discovery that in the district attorney's mind, and the testimony was such that they did not have an obligation to turn it over unless advised that it was out there by the police department. So they do not have a separate process for determining the existence of exculpatory evidence. And I could go on in detail, but I know your time, and I'm very happy to, by the way, but I understand your.
Oh, I don't care. You can take all the time you want, because I think this is important for a whole bunch of reasons. One, because it's being essentially used against her.
Yes.
But also because this seems to have been, for whatever reason, a conscious decision by the DA and the police department to not release information that may have exonerated somebody from a crime. Is that correct?
That is a question, and it's a question that's up before the SJC right now.
So it's quite real if the SJC is seeing.
It is more than real, and at the same time, I will add to that, and something that might be of interest or that you might want to turn to is, I think it was last week's edition of Massachusetts Lawyers Weekly. Has a front page article, and worth reading because it crystallizes these issues. And of import is that not only is the Christopher Graham, he's the lead defendant, the lead petitioner before the SJC, many other defendants as well. It's simply his name, Innocence Project is involved, so on and so forth. But be that as it may, it turns out that because of issues involving the Springfield Police Department, involving issues impacting the communities of color in Western Massachusetts, particularly in the greater Springfield area, that the federal, right now before the First Circuit Court of Appeals, has taken up a companion issue regarding the alleged failure, because they haven't made their decision yet. The alleged failure of the district attorney's office I take that back. With respect to the Springfield Police Department, I take back what I just said about the DA's office. The Springfield Police Department to not turn over material. And they're also addressing in the First Circuit, as I understand it, following a DOJ investigation, as a matter of fact. They're also taking up other related issues, many of them dealing with issues of race.
So this DOJ and everything, it's all related to this.
Not Graham, but it is of the same kind, if you will.
So I get it. So had there been transparency with the police department and the DA, none of this would have ever happened, and that thing about that you wrote never would have happened, because she would have been given access to exculpatory evidence.
Yes, and I will let Attorney Duncan speak to her own experience on that. It would have assisted me, whether my decision would have changed or not. It would have assisted me certainly in knowing whether or not why this was not turned over in automatic discovery.
Well, thank you for the explanation. It clears a lot. I mean, to me, it was a little bit, as I always say, the elephant in the room. I had spoken to her about it. And then when I heard you were going to be here, I'm like, no one better to address it than you. And it is, it's more complicated and frankly, more disturbing than I thought, particularly considering the jurisdiction that it happened in the history of, as you well know, in that jurisdiction. So thank you. That's it. Thank you.
Thank you. I turn it to Counselor Kennedy.
Judge, I've been a criminal defense lawyer for 40 years. I have to tell you, your decision was pretty scathing. It was probably one of the toughest decisions I've read in how it went after trial counsel. It was pretty strong. I mean, and it wasn't just about a 911 tape. You talked about her closing argument. You talked about how it was cursory and perfunctory. You gave a list of all the things that she didn't address, and it's not just a 911 tape.
Right.
And frankly, usually Superior Court judges, District Court judges on a motion for new trial, they try to soft pedal it in terms of protecting the lawyer a little bit. You seem to have done just the opposite. I mean, the language you used was really, really harsh.
Well, it may well be. That's in the judgment of the reader, and I would not quarrel with.
As a criminal defense lawyer,
I understand
reading it,
that.
making a judgment about it, it's the harshest language I've ever seen where a sitting judge went after a trial lawyer's performance. They usually soft pedal it, you agree with me, usually they'll soft pedal it a little bit, and find a way to get there without going after the lawyer the way you did. It was pretty harsh.
Well, obviously, I respect your analysis of it.
Trial counsel's closing argument was cursory and perfunctory. In her cross-examination of Commonwealth witnesses, she neglected in the closing argument to mention significant weaknesses in the Commonwealth's case. That's not about discovery. That's not about a 911 tape. It says those included McNabb's highly suspect claim that he was unaware of the crowd's presence or the person in the crowd had attacked the other people. How Fumi's account of how he fell unconscious just as the defendant was lowering his gun from his chest. It just goes on, and you just point out every single thing that she either didn't cross-examine about or that was there. This wasn't something that wasn't hidden in discovery. I'm going to talk about the discovery issue in a minute, but I mean, this is stuff that went on during the trial, and you went after her for the way she cross-examined witnesses, and you went after her for what you describe almost as a total failure in her closing argument, which is obviously huge. So how do you reconcile that with your testimony today?
I'm not attempting to.
Right away, I just want to say something. Like I said, I've been a criminal defense lawyer for 40 years. I've signed affidavits saying I missed something.
I'm sorry, I didn't.
I've signed affidavits on motion for new trial saying I missed something. We all, as my friend Joe Bolero said one time on a motion for new trial, to err is human, a new trial is divine. That's a quote from him. But I'm reading this and I'm trying to reconcile with your testimony today, because that doesn't match that.
Well, I spoke to the major issue that was before me, if I could.
But your decision wasn't based on a 911 tape, missing 911 tape.
My decision was based on the totality of the evidence presented to me during the hearing and my own knowledge of the trial. And in terms of harshness or in terms of going after a lawyer, all I can do is rule on the evidence and let people to their own judgment as to whether or not I was fair or not. I can't make that decision.
You didn't criticize the DA's office in your decision for not producing exculpatory evidence. You criticized defense counsel, trial counsel, for not filing motions to go after it. Hey,
Yes, the decision is
that's what it said.
absolutely.
Today you talked about, by the way, I think she's terrific, but this is troubling, okay? I've been doing it every day for 40 years. I've never seen a decision like this before. And I get the issues with exculpatory evidence. We're having huge issues in the Commonwealth of Massachusetts over the last 20 years between the drug lab scandal stuff, the Drager stuff with breath tests, with prosecutors withholding evidence and making decisions on their own that something's not exculpatory. I mean, we have a huge problem, and it just seems to keep happening over and over and over. They're not getting the message. And if the Springfield police or the prosecutor's office out there, I don't go out, I've been out there in the past, but I don't go out to Western Mass very often. To me, that's west of Framingham, as I said earlier. But I don't know how you solve that problem. I mean, I don't know how you get the message to them that you can't keep doing it. Maybe it's with what recently happened to two assistant attorney generals that because of withholding it. But I don't know. People just don't seem to be getting the message. But I'm having a real hard time reconciling with your description of the nominee today and your description of her performance in that case, because that was scathing, that decision. It's probably the toughest one I've ever seen in terms of an evaluation of trial counsel's performance.
And all I can do is respect your judgment. However, I based my ruling and I stated my reasons.
I respect your ruling. I'm not saying you didn't do the right thing. I'm just, you know, it's just perplexing that here you are sitting here telling us how great she is. She may very well be. And then you have a decision that just rips her, but more than I've ever seen.
Well, all right, I understand the language you're using. My language is my language in the decision. But please, you must take into account the body of work she has had before.
I intend to. I'm not, I didn't say I wasn't voting.
Before me, the body of work she has had before me, which has met a very high standard. Is this an exception? Yes, it is an exception, without question. And the reasons therefore I stated. And there's nothing more I can say beyond what I stated. But I'm not here today to just talk, I'm here today to answer any questions you have, but I'm also here today to represent to you that the body of work she has had over a long and highly, highly sophisticated career has been, on the whole, excellent.
Judge, I think it's important that you are here today, because if we were just sitting here with this decision without you saying something positive, that would be difficult for us to get past.
I understand that.
And I appreciate you coming.
Thank you for those direct questions, and I really do.
I turn it over to Counselor Ionelli.
Thank you. You know, as I sit here, I agree with 99% of what Kennedy said. If I was sitting in that chair, you would have been the last person that I would want to speak on my behalf. The last person. I mean, your decision was really, really, really tough. And for you to be, did you expect questions on this case?
Certainly I did. I reviewed it again before I came here. Absolutely I did.
Me, I'm just giving you to me, just my personal opinion. Really, it's an example of poor judgment on the nominee, because I never would have had you here. I never would have had you. I understand what Councilor Kennedy says, but for me, I never would have had you here. And you've been a judge for, I know you're retired. How many years were you a judge?
34.
And how many cases did you find ineffective assistance of counsel? Is this something that you normally do?
No.
Because, well, before you answer, most judges don't do it. Don't find ineffective assistance of counsel. I didn't know if this is something that Judge Sweeney does on a regular basis. That's what I'm trying to get a sense of.
Of course not. Without, going through the file cabinet in my head, I'm going to guess that maybe over the course of 34 years, it would have been a lot if it was one a year. That would be a lot, so it's something less than that.
You do this.
That's correct.
And for this nominee, you did it in a, I look at it as an extremely tough decision against her. I never would have had you here myself. I personally think, you can obviously have as many people and as fewer people as you ever want. Like I said, she would have been the last person that I would have had. Nothing against Judge Sweeney. I think she had an outstanding career. I respect her highly, but I'm just talking about this nominee. I would not have had her. What can I say? As you know, I did get a call from former Chief Justice of the Superior Court, Suzanne Del Vecchio. And yeah, I don't have any more questions. Thank you.
Thank you. Hello, Judge. I last saw you in 1992 when I was Superior Court Law Clerk, like 30 some years ago. I didn't realize you were on the bench for 34 years. How old were you when you got on the bench?
36.
Wow, just a kid. Well, good for you. Thank you for your service. I have a different background than some of the people on the council. I was a cop for 30 years, I was a police chief. I've been a lawyer for 30 years. I've been on this council for 9 years now. Sounds like I'm 100. But I do agree with Councilor Kennedy that it was, I thought a scathing decision as well. But I want to, I differ with Councilor Ionel. I do want to congratulate you for being here today, because I agree with Councilor Kennedy, that by itself is difficult to digest without explanation. So I appreciate you coming here today. If you had to write a decision today, would you write the same decision?
You know, I can't answer that honestly because we don't go back, or I don't mean to say we, I don't go back and look at my prior decisions unless there is a reason to do so. And that reason did not arise. And my findings were my findings. I'm not going to take them back or be mealy-mouthed about it in any way. My findings were my findings. And was it the exception? It sure was. Absolutely it was.
Are you aware of any other cases where the nominee was accused of being ineffective assistance of counsel?
No, but I've never looked for that. I've got to be honest, I've never looked for that.
No BBO complaints that you know of, none of that?
No.
No, it's important, so.
No, appreciate that, but no, not at all.
Thank you. Thank you. Thank you.
Did you have anything? No? All right, well, thank you so much for your testimony.
Thank you, officer.
All right, our next witness I'll call is Attorney James Goodhind from Springfield, Massachusetts.
Thank you. Good afternoon. My name is James Goodhind. I'm a criminal defense attorney from Springfield, and it's my pleasure to be here on behalf of Tracy Duncan, an attorney I've known for 29 years. I'd like to thank the governor, lieutenant governor, for nominating Ms. Duncan, and the governor's council for allowing me to be here. First, I want to say just a quick point about what was just discussed. I've known Tracy for 29 years, my first 16 years as a prosecutor, in which I handled cases with Tracy from the juvenile court to the Springfield District Court to the Holyoke District Court, where I was the chief. Then I was promoted to the Superior Court, where I handled cases against her for 12 years. And in the last 12, going on 13 years, I've been a criminal defense attorney. Tracy Duncan is one of the finest lawyers I've worked with in my 29 years. I'm going to say that again. She's one of the finest lawyers I've worked with. And when it was said that Judge Sweeney would be one of the last people that you would want to have here because there was a opinion said against her that would be something you would be afraid of to have heard or discussed, then you don't know Tracy Duncan. I'm an emotional person. Tracy's an emotional person. So if I get a little emotional, if I start to turn red, the back of my neck, that's who I am. Tracy is emotional, but she does not allow it to affect how she presents. So when she had Judge Sweeney come to speak on her behalf, you heard Judge Sweeney say that on the body of work that she's been in front of the Superior Court for over 20 years doing cases, that by and large, all of those cases, year after year, court-appointed cases, some of the hardest defendants, some of the most serious offenses, Tracy's handled those cases with dignity, dealing with defendants in her face, complaining about the cases, complaining about the prosecutors, complaining about what was going to happen. Tracy kept this same composure. I'm abandoning my scripts. I wrote a 2-page, 3-page statement that I was going to give today, but I have to rise up to defend the position that we are in. She is here because she deserves this opportunity to be a Superior Court judge. I've handled personally over 50 cases, from juvenile through the district court and most in the Superior Court. Tracy is a woman of poise, of grace, of talent. She's prepared. She reviews her cases. She understands her clients. She's had clients where she represents practically everyone in the family. Springfield, Mason Square, is a community in which lawyers are very infrequently trusted. Very infrequently will they hire private attorneys, but they do. And when they do, they hire Tracy Duncan. Miss Tracy, or Miss Duncan as they refer to her, is the person they go to because they know she represents them in their community. She will stand up for them. She will fight for them. She will work hard. She will understand her cases, and she will defend them till the end. So in a case in which a 911 call was not turned over, and quite honestly, practically every attorney that I know that would have been a defense attorney in that case never would have even known to look for that information, wouldn't have even asked for it. And it only came up after the decision issued by Judge Sweeney, and not known to Ms. Duncan at the time. So all of this information that came to light to help this defendant, who's entitled, hopefully, to a new trial and is justified in being given the opportunity to defend himself justly, was not information she knew about at the time. So in the decision that's given, Ms. Duncan did not fear the decision that was made. She did not try to defend herself or say her client didn't deserve a trial. She simply stood pat and said, let him defend himself, as you and I both know, in authoring affidavit saying, please give him his chance at a fair trial. We make mistakes. She's a fine lawyer. When I was a prosecutor, there were cases that she would say, as I heard her good friend who's here today, Cliff Flint, say on Monday night when we had an open meeting. Tracy's a woman who always says, let it be fair. Be fair. When I was a juvenile prosecutor, I had a case in which a juvenile who was 11 years old charged with a drug case. I'm not going to say names. And Tracy said, he didn't do this, take a closer look. And when I took a closer look, I realized that the story that was given in court and the story that was on the paper didn't match. And so the case was no pros, and the case never went forward. Because that's the kind of work that Tracy would do on her cases. And Tracy, as I said in the letter that I submitted, is the kind of person who would say, I know when I have a case and I know when I don't. And that's because she prepares. She understands what she needs to do in her cases. She was always effective on both sides. And now as a defense attorney, I frame most of what I do on things I've learned from people like Tracy Duncan about how to be passionate, how to care about your clients, and how to work hard and be respectful. The Superior Court needs the experience of people like Tracy Duncan, who represent our community, to help people in the community embrace that her perspective, her experience is going to work for Hampden County and the 4 Western counties. This council would do Hampden County and all the 4 Western counties a service by making her an associate justice. Thank you.
Any questions? No, so debating.
I have to say that today, everyone who's sat in that chair is experienced and they know this nominee, and that means a lot to me. Now, with all the experience that you've had with this nominee, is there anything that you look back on any case that really stood out? She conducted herself in a most dangerous case.
Well, without getting into these names, because some cases are still pending. When I left the DA's office and went into private practice, Tracy and I have had co-defendant cases. And at times, despite the number of cases I worked on as a prosecutor, you run into situations where you don't always know the right thing to do. And Tracy is one of 5 people that will pick up the phone and say, have you encountered this issue? And there is a particular case that I have in mind in which, because of the contact I've had with her, that it led to further phone calls and further motions being filed on the case. And that as a result of that, the case has lasted longer than it normally would. And it's because of her insight and her understanding about the nature of these kinds of cases that she and I do, which primarily for me in the Superior Court are drug and gun related cases that have led to motions being filed in the federal court, discovery being sought from other sources that wouldn't normally be considered by the average attorney. And I thank her on a regular basis for the fact that she has the experience that allows me to think beyond papers that are provided. So I would say that kind of work I think is helpful, and it will be experience that she brings to the bench that is unique.
Well, I'm very pleased that you came because you're able to really, you've been there, you've heard her all through the years, and that means a lot to me, that you have that experience. And it's sincere, and your respect for this nominee means a lot to me.
Anyone else have any questions? Seeing none, thank you so much for your testimony. Our last witness, I call up Carla Tucker Kennard, who is Senior Probation Officer from Hamden Superior Court Probation Department. Welcome.
Thank you. Thank you. Good afternoon. Members of the Governor's Council, Councilor Tara Jacobs, it is a pleasure and honor with great enthusiasm for me to be here at this historical moment. To be before you, so I may share with you my professional opinion here of Ms. Tracy, Attorney Tracy Duncan. Again, my name is Carla Tucker Kennard. I'm a Senior Probation Officer employed with the Massachusetts Trial Court, and I am at the Hamden Superior Court Probation Department. I am approaching my 37th year come March 18th in 2024 to have been in service with probation. In my capacity as a probation officer, I have worked closely with Attorney Duncan on a number of cases where Attorney Duncan has represented many defendants, probationers who are before the court for surrender hearings / VOPs, modifications and motions, and there such as. The Hamden Superior Court is one of the busiest courts in the Commonwealth and deals with diverse and challenging populations and individuals who have serious offenses. Attorney Duncan, when representing these probationers facing violations, is always ready and on point. She's always greets her clients, the probation department, the clerks, the judges, court officers with a smile and is very professional. Tracy is a fighter for her clients, and she's a negotiator. Attorney Duncan exudes exceptional professionalism. She has an even temperament. She's excellent legal acumen. She has a common sense savvy, which is needed when facing the day-to-day work that she does when dealing with the criminal defense, while always working on the best disposition for her client. It is important for you to know that her client and the challenges that they struggle. Tracy delves into her cases to find out why her clients may be committing these offenses or allegedly committing these offenses. Is there abuse? Is there a drug addiction? Is there an educational component? And she does that because we don't like the recidivism where you're coming back into the court. So we really dig into that, and she works with probation on that. Because everything is not just incarceration, as it has been proven by evidence-based practices. Tracy has always demonstrated a respectful manner to her clients, and I can't impress that enough because we're dealing with a vulnerable population. They're already nervous about what they're coming into. They don't know what they're facing, and their first port of call, other than probation when they're having their intake, is who's going to be my attorney? First thing they say to probation, are they a good attorney? Which we make no comment on. But in my head, I'm saying you have a very good, capable attorney. That's who the courts give you. And I know that she is always honest and engaged and present, and her demeanor has spoken about earlier are the key ingredients which are needed They're very much needed, especially in the Hampden Superior Court and in the Western Massachusetts. Just want to say that in my nearly 37 years of being here before the court, I have only witnessed one Black or African-American judge who has been in the Superior Court bench. And that is retired Honorable Tina Page, Justice Tina Page. And when that happened, it was a catapult. This glass ceiling was broke. It was tantamount in the courthouse. I can't describe the feeling we all felt. From district court, probate, and juvenile, we have an African-American judge in Hampden Superior and Western Mass. And that's among all the 4 counties, Franklin, Hampshire, and Hampden. She was a trailblazer. It continues to be a trailblazer and a mentor, even though she's retired. So now when I'm nearly closing down to my 37th year and I'm seeing myself have retirement on the horizon, to be here today and to be here, because Tracy is also a personal friend of mine and we're in other organizations, but to be here to witness this, it's needed. The tide needs to turn. We need another associate justice of color, and it's a woman, to be in the Hampden Superior Court and to have before us the people. And I want to thank you, the Governor's Council, at this time. This is your time. Thank you, Tara Jacobs, for recognizing Western Mass. We are here and we are speaking and we are roaring. And we are so excited and we feel so confident, so happy to have had Tracy Duncan to be a nominee. And she has earned her stripes. She has proven it. And if you bring any of her clients here, they would say the same, or any people in the Hampden Court, District Court probate. So that's what I'd like to add to you for today as a witness. I'm honored to be a witness and to be before you. Thank you.
Thank you so much. Counselor Devaney.
That was so heartfelt, thank you. I have to tell you, this is a new day. We have an open government now with this administration, and we're going to see more. And women, I couldn't be happier. I waited 8 years for this, so, but, you know, I am very impressed with you saying how the nominee has continually worked with you as a probation officer. Now, in your 37 years, is that the norm? Does the lawyers work with probation officers like that?
Well, let me just say, probation, the trial court, we have taken a tide where the jails are exploding. We have to do something and find out what can we do so that we can have individuals who are coming before the court. It's not necessarily all the time. And yes, all the attorneys now are working with probation. Some defendants, yes, it calls for them to be incarcerated. However, through evidence-based, we need to figure out what is going on with the defendants. What do they need? What are their challenges? What are their risk needs? And so when we come down to that, we have individuals with severe mental health. We have individuals who have had a drug addiction, individuals who've never been to mental health counseling, who may have been abused. All of that, when you look at a record, sometimes you can look at a record and see several shopliftings and burglaries. You're like, well, okay, there may be a drug issue here. So if we can try to work together, so we're not having recidivism, and we can try to see what is this client's issue, what is it that we can target, and you can try to get them in the appropriate place, then yes, they are working with us, and we're trying to do that, and we're trying to work together.
Well, you're saying exactly what she has said in her questionnaire about what are the most important things. And when that person comes, what is the harm to the victim, to the defendant, to everyone, society, but also she said to look into family history, mental.
Yes.
And I don't see that a lot in the questionnaires, that they answer all of that. You know, it's kind of general, you
Right.
know, that I see. But that was very, she really focused on what she felt was important to look at. And I think, you know, being in her line of criminal work, I think that's very important.
It is.
your testimony means so much because you've worked so long. 7 years, God bless you.
Thank you.
That's wonderful. Thank you. And I think probation officers get the due respect that they deserve. If you have my niece and twins.
Okay.
Yeah.
That's like,
Yeah, right, you might have known her, but, you know, I just have such respect for you and for what you came, thank you. I mean, this is such a testament to this nominee,
I
really.
appreciate it, and I'm honored to be before the council.
Well,
Thank you.
so much, it means a lot.
All right, thank you. Does anyone else have any questions? Okay, thank you so much for your testimony. We appreciate it. We're going to close this portion of the hearing and ask if anyone else here today has come to speak in support. Okay, well, seeing none, the next section of the hearing, is there anyone here today who has come in opposition to today's nominee? Seeing none, we're going to close that portion of the hearing. And at this point, I'd like to invite Attorney Duncan to give her statement to us. So please share with us whatever it is you'd like for us to know about yourself and why you would be a good addition to the Superior Court.
Thank you. It is the highlight of my life to appear before the Executive Council as a candidate for Associate Justice of the Superior Court. I wish to thank the Honorable Maura Healey, Governor of the Commonwealth of Massachusetts, for the nomination. Lieutenant Governor Kimberly Driscoll, Valerie McCarthy of the Governor's Council, Paige Scott Reed, Counsel to the Governor, Emily Gauthier, JNC Executive Director, Daryl Kesselheim, JNC Deputy Legal Counsel, and the Judicial Nominating Committee. I have 3 witnesses who traveled here today: retired Justice Constance Sweeney, Attorney James Goodhines, and Senior Probation Officer Carla Tucker Kennard. Finally, Western New England University School of Law for graciously hosting a public hearing on Monday, as well as those who testified before the hearing, and Counselor DiPaolo for attending the hearing. Finally, my family and friends who traveled here today. I am the daughter of the late David A. Duncan III and Debbie Davis, who's present here. She has supported me throughout this process. I grew up the product of a middle-class family. My father was a mechanical engineer for Pratt & Whitney, and my mother a registered nurse. My father graduated from Wentworth Institute in Boston, and my mother attended nursing school at Mercy Hospital and obtained her bachelor's degree while I was in law school. My parents set the standard for my life by stressing the importance of education. When I graduated from law school, jobs were limited. So I hung up my shingle and became a solo practitioner and worked as one ever since. I'm a trial attorney. I try a minimum of 5 trials per year and have an extensive motion practice. I treat each client with empathy and dignity. I'm a zealous advocate, yet I analyze each case realistically. I always look for a fair resolution to any matter I handle. I have an even temper, excellent legal judgment, and over 30 years of experience. I represent indigent and private clients before the U.S. District Court of Massachusetts, the Superior Court, the District Court, and the Juvenile Court. I currently serve as defense counsel to the Restart program in the U.S. District Court in Springfield. It's a restorative justice program that assists participants with securing housing, a GED, employment, mental health, counseling, and parenting skills. 3 individuals have participated in the program, 2 have graduated successfully from the program, and the 3rd is on the way. It brings me great joy seeing how they've progressed in the course of this program. I discussed my criminal experience, but I do have a limited civil experience. I have tried, or not tried, but represented two individuals recently in civil rights litigation. Regardless of the issue before the court, the decisions are driven by the facts and the relevant case law. There's a saying, to whom much is given, much will be required. I've given to my opportunity by my community by the two organizations that I participate in, that I'm a member of, the Greater Springfield Chapter of Links, as well as the Springfield Chapter of Girlfriends. Both of those organizations provide beneficial programs to the community. I currently serve as a mentor at the STEM Middle School program where we are helping the students participate in a mock trial at the district court in Springfield. I wish to become a Superior Court judge because I've observed the lack of diversity on the court bench in Western Massachusetts. When I first began my practice, there were four judges, 4 female judges of the 11 that serve on the bench. We currently only have 2 female judges on the bench. And as you heard, no African American, and that's for Western Mass. If confirmed, I will be the first African American born in Springfield, still residing in Springfield, to serve on the bench. I will be the second African American to sit in the Superior Court in Western Mass. And finally, I will be the third African American of the 82 currently seated judges of the Superior Court. This day is momentous for me, but more so for the city of Springfield. The children of the city deserve to see that with hard work and determination, that they too could possibly be a judge. I thank you for this opportunity and request confirmation.
Thank you, Attorney Duncan. I'm going to turn it to my counselors to ask, to take the floor and ask you whatever questions they wish. First, I'm going to start with Counselor Ferraro.
Thank you, Madam Chairwoman. Thank you for being here today. It must be tough sitting there when everyone's talking about the worst case you ever had, right?
Well, I don't look at it as the worst case I've ever had. I was there, I participated in that trial, and I will tell you that I gave my client an excellent defense. We did have one witness that was present, indicated that my client did not have a gun on his person, and he testified to that during the course of the trial. But of course, during the course of that trial, there was a gun that was reported that my client had. So it was a jury trial, so of course, naturally, I have to explain away that my client didn't have that gun during the trial, which is difficult. It's difficult. And so with that, the jury found my client guilty. I had one witness who testified my client didn't have a gun. But also, there were 2 or 3 other charges. There was the possession of the gun, possession of ammunition, and then there was a charge in regards to assault and battery on another party. And with that case, the jury believed the defense and they found my client not guilty of that charge. But you have to be able to explain away the gun. And if I had that exculpatory information, that would have been another person that would have testified during the course of that trial who could have perhaps persuaded the jury that my client didn't have the gun. The gun came from somewhere, and so they believed it was my client.
I was gonna ask you if there's anything else you wanted to say about the case, that's all.
But I just wanted to explain that.
No, I think you did well by bringing the judge in so we could ask her direct questions. So I appreciate that. You told me, we spoke briefly, you said that you had done some civil work too?
I've had some civil work through the course of my career, but I'm not a civil attorney, and I'll be the first one to admit that. When I first started my practice, I handled care and protection petitions in juvenile court. That's civil. And that's something that does appear in the Superior Court at some point if they do like an administrative appeal. I've also handled some housing court cases in housing court. And like I indicated, I've had 2 civil rights cases within the last 7 years with my partner, Jean Liddy. I've also handled some administrative appeals before the Unemployment Board and as well as the MCAD.
You have any idea what percent of the cases Superior Court are civil in your county?
Well, the two cases that I handled were in US District Court that were the civil rights cases.
Have you done anything to prepare yourself to handle civil cases, like the big medical malpractice cases, or, you know, car accidents, or slip and falls, or wrongful terminations, any of those things?
What I've been doing is I've been reading the rules of civil procedure. And I can tell you that I know, well, if appointed, I will be going to judges school, and I know that they will assist in my preparation with that. But it's my intention also to attend any judicial conference with regards to civil procedure or medical malpractice, or any civil case. Civil is a wide range of cases, so it's not just slip and falls or civil rights violations or medical malpractice. It's a big practice. So the only thing I can say is it's just like when I started my practice. I studied. I worked long hours, read case law, and I believe with the civil practice, what will occur is an issue will come before me. It will be briefed. I will take a look at those facts, do my own independent research, as well as the briefs that come before me. And I will rely on my fellow judges. Judge Callan will be my mentor if approved, and all the other judges of the Superior Court to assist me with my decision-making process.
I'd be remiss if I didn't say you have a big fan to my left here. That's a big advocate for you, so thank you.
Thank you. Counselor Devaney.
And nice to see you again. I can't thank you enough for traveling that distance to Watertown to visit me. I don't know whether Judge Island beat you. I think it's he went a little further. But it was so nice, and I really appreciate it. And I want you to know, you weren't nominated because you're Black or because you're a woman, because you're exceptionally qualified, and that's important. But as I said, there's going to be a change. You're not going to be alone. So the thing is that first of all, I love that that you have your own office, and that you were a solo practitioner. And I know my friend, Councilor Ianella, she has that same, thing that he likes to see people solo, because you're not given the people to represent. You choose who you're going to represent. And you have to be responsible for the heat and the lights and shoveling the snow and all of that, which I think is another added, another attribute bringing to the bench, that you understand that people are coming into the court. And when you see, this is my own idea, but when you see someone coming in with a client, you realize what they're paying for the lawyer and everything, so you have all of that. So, I was thinking when, you talked about, having, people of color. Years and years ago, there was someone before us, and it was a Black man, very qualified, and 4 people came in opposition because he was going to a district where he didn't live. And he said that he would move there. He said he was going to do that. But 4 of them came and said, we need someone from our district. And I can remember like it was yesterday. And I said, you know what you need? You need someone who reflects the people that come into your court. And I only won that by 1 vote. And he's in the Superior Court. I'll tell you later. But, your whole philosophy is so impressive. And as I'm concerned about criminal, because I have my own personal feeling after 25 years here, that I'm concerned about someone, a judge that's never done criminal cases, to be timid about giving the correct sentence. I really believe that. And I could be all wrong, but I think you can learn civil, and you've had some civil cases. So, anyway, so you are prepared for that. Now, have you defended people? I mean, you've defended people accused of raping a child and found innocent and gone on with the life and all of that. Do you ever have these people later in life that contact you or see you and thank you for what you've done, that they, that you turned their life around?
Quite frequently, I've had clients, former clients, come up to me and say, thank you so much for what you did. And I always say, oh, I must have done a good job because I don't recognize their face, or I don't recognize them by name. But people have come up to me, like in the Walmart or the grocery store, and express how much I've impacted their life. So,
No, I mean, I think it's very hard to be in court, defend someone who has been accused of egregious crime. And that you can present it so that this person can go on with their life. I mean, sometimes you've had them, they've had to serve in prison, but when they come out, I mean, it's a whole different life of what you've done. So, what is the most dangerous case you've had?
I've had several, but the worst case I had, Judge Page mentioned it at the hearing, was this young lady injured my former boyfriend's new girlfriend. And there was a pot of grease on the stove, and she heated up that pot. And she threw that pot of grease on her, the girlfriend, as well as her two children who were in the bed with her. And it's just the facts of that case really to the core, because that was basically someone coming into your home, your private area at night when you're asleep and you're safe.
Well, we gave me so much time. I really appreciate it when we met. And I was very impressed with your experience with youth. And I have a little personal experience. I volunteered a year with juveniles on probation. And here I live, my little life, with 4 children, husband. I really had enough. And that was the best thing that I've ever done. I found the other side of it. And I met with, I remember one teenager, and the mother was a prostitute. She used to lock her in the bedroom. She didn't know who was happening. But I mean, when you think, and that's what you look at. I love that, what you said. You look at their history, look at the family, all of that contributes to how this person got there. And I learned so much, and I think that was the best experience I ever had. And I met them one-on-one, and it took a long time to get their confidence to trust me. And it was the best year that. And so tell me how your experience with youth adds to your qualifications to be on the bench.
Well, I started my practice in the juvenile court. Relationships with those clients. Some of them transitioned or they moved with me when I entered the district court or the superior court, even some in the federal court. But it's like when you see someone as a child or as a juvenile and they move on, you know some of the history that they have with or with that person. And the history is important because sometimes they just don't have the same benefits or opportunities that other defendants have. So to me, if they've had a juvenile history, sometimes could have framed how they turned out in life.
Now, what is the most rewarding case? Is there one that you can look back on?
Recently, in the last 5 or 10 years, I had a client come up to me and in the courthouse, he said, Tracy, remember that case it was overturned. And I said, really? And that was the case where I had argued an issue of constructive possession and whether my client had dominion control over some drugs that were in public, close proximity to him. And so he was sentenced, I think, for either trafficking or second offender possession with intent. But his sentence was terminated early. And I made a difference on him because he was able to get his case overturned, get out, and now he's productive. He's a productive member of society. So that's what I remember as one of my most positive cases.
Well, I've always said I would never vote for anyone that doesn't have compassion. And it's stamped on your forehead, I'm sorry, compassion. But someone said caring. And you are, and I found that when I met with you. And I am so grateful that you took the time to come out and to see me, because it's very important to me, because I'm voting for the whole person. And I just don't want to come into a hearing or read your resume. I want to meet you, and it was such a pleasure.
Thank you.
And I wish you all good luck. I don't have a poker face, you know, I'm gonna vote yes. And I'm just thrilled. And this is such a tribute to you, that these people came the distance to honor you. That's amazing.
Come from a good community,
It really, really is. And your mother must be so proud.
definitely.
And your dad's with you, believe me, he is. So before we both cry, I thank you, and I thank the governor and lieutenant governor, and thank you for this new day of justice. I really appreciate it. Thank you. Oh, I did want to say, the people, she applied twice, district court and superior court. Shame, shame. And that's why you have to keep applying, because we could lose someone like you, that you would be discouraged, because what are they looking for, you know? So thank you.
Thank you, Counselor. Counselor Ayala.
Thank you very much. Good afternoon, how are you?
Good.
I like you. I like your demeanor. I like your temperament. I like the fact that you're a sole practitioner. I know do you work for yourself in the sense that, do you have any support staff or is it just you?
It's just me. I do everything.
Okay, and that's fine. So let me ask this. It's hard because maybe it's supposed to be at this court at 9 o'clock and then this court at 9 o'clock. So if someone who's a sole practitioner, you can have to jump. So you're going to have to ask for a continuance. So, in your experience, how have the judges been in your area when you request a continuance?
I can say that when I've requested continuances in the past, I haven't had much difficulty. They usually want to hear the reason or the rationale for the continuance, but they have been very gracious with me.
We had a nominee sitting right there 2 years ago. I asked her a question. I said, "What are you continuances?" I said, I hear a lot of stories out there. I mean, it's tough out there, as you know. You know, clients don't pay you, you gotta pay for the whole life, they're gonna pay the heating bill. It's tough out there. And with advertising out there, the competition's fierce. So, what would you do in this situation? I said, what's some your spouse came in night before, we're supposed to be on Tuesday nights. Mary, Mary, we've lived together, we've been married for 25 years. I'm taking you to Bermuda on Friday. I said, what would you do if somebody came before you and said that to you? And they asked for a continuance because it was, in this hypothetical, it's a real hypothetical. The spouse is gonna take you on a surprise, wedding night, anniversary vacation. What would you do if someone came before you on that? How long would it take you to decide that, make that decision? How long would it take you?
So That's not even a question. If they,
Yeah, exactly. And you know what this person said? It's not. I'm supposed to put my schedule. He never should have had that vacation planned. Are you kidding me? You are kidding, right? And she said, no. No.
We're divorced now.
So especially you know, which I like, you've worked for yourself for a long, long time. You need continuance. You go here, you gotta go here, and let's be fair. Kennedy knows this better than I do. I don't do criminal work. When Mr. Green shows up, you know who Mr. Green is?
yes,
Yeah, you got an arraignment tomorrow, but you got another case in another court. You wanna be with Mr. Green? He's the guy with the money. So I hope you're gonna be, you know, as lenient as you can with continuances, especially with these sole practitioners, because it is hard out there. Remember, if it's a big firm, or if it's the DA's office, they can get someone else in the office. As well, hey, we handle this case, you handle this case. People like you can't do that. It's hard, so I'm glad of that. I have to ask you this question. You don't have to answer. I can't believe, as I sit here, and I think the world of Judge Sweeney, she knows that, but I can't believe, and don't answer this, that you to be a witness on your behalf. And to me, I'm sitting here, and I said it to one of my counselors. I said, she had to volunteer to come in here. There's no way Tracy Duncan would have asked her. Don't answer. Because it was a tough decision. And let's be fair. Let's be fair. You already have my vote, by the way. I told you that. How did you feel when you read that decision?
you want me to answer that?
Pretty easy question for me.
I already said how I felt, which was, I didn't think I did a bad job.
Yeah, you said that. I did a great job. It was the very best defense I could do. You don't have to, I'm not fair. You know, like I said, I really have a lot of respect for Judge Sweeney, but that could have ruined your career.
Could have.
Easily could have ruined your career. Let's be fair. You could have got a BBO complaint
Could have.
after that. You could, and I know you applied with Judge Baker. Am I right? And I don't know this, but this is, you can answer this one. When you applied with Judge Baker, Governor Baker, sorry, Judge Baker. It's late in the afternoon. When you applied in the Baker administration, did you go in front of the JNC?
I made it to Governor Baker's desk and I was interviewed by Governor Baker.
And let me ask this, whether you went in front of Lauren Green, Bob Ross, those are the staff of Governor Baker's who vetted out judicial nominees. Was this case, Greg, ever brought up?
Discussed.
It was discussed. And we can all imagine when that case was discussed, what the verdict was. Why? And you can't blame them. You can't blame them. I am so happy you persevered and came back. Because your dream of being a judge could have been ended. And I'm gonna say it again. But you're gonna be compassionate. I think you're gonna be a better person because of Judge Sweeney's decision. I really do. I'd be surprised if I see you in 25 years. I'm sure. Already the longest serving counsel. Have you ever found a defense attorney for ineffective assistance of counsel? I bet you that answer's gonna be no. It's damn hard to find that against a defense attorney. We're all working hard. But I like that. I like that. My last question is, I've always been a strong believer, if possible, rehabilitation versus incarceration, if possible. obviously, if the defendant's got a record of marijuana, you know, what are you gonna do? But tell me your thoughts on that.
As a defense attorney, when I present sentences to the court, I always look at the facts. And I try to frame a sentence, if it's needed for incarceration, to include some incarceration, but I would prefer to have my client be on probation after a period of incarceration, as opposed to just giving someone like a straight state prison sentence. I believe they need to be able to transition into the community to become successful. And the only way they're going to be able to transition is if they're involved in some form of probation with services.
Totally agree. Last question. My friend Bob Jewelville, he's one of my best friends. He's no longer here. No, he hasn't gone right. He's on another court. It's not upstairs. He always asks this question. What if there's a mandatory sentence? But you know what? Mandatory sentence, there are some which you have to go to jail. Whether it's a year to, it's mandatory, it's no discretion. You know, one judge who says, I know it's a mandatory discretion, a mandatory sentence. I can't do it. I just cannot do it. What would you do in that situation? Because I don't know if you know what I'm talking about. And they can't buy these junk. They're for life unless it's something really, really bad. It's not gonna happen. What do you do in that situation? Check break closure.
That's a hard one because you have to impose what the legislature has given for a sentence. I have witnessed judges, though, delay cases, and hopefully with time, maybe the district attorney's office will change their mind. But
Because they can reduce it or make it less of a offense. I don't know, bro. All right, you know what? Like I started my first segment, I like you, and I'm gonna be proud to vote for you next week. Thank you.
Thank you, Counselor. Counselor Jeff?
Thank you very much. Thank you, Attorney Duncan, for all the time you gave me when we spoke. And I'm actually very glad that you brought Judge Sweeney with you. To me, it was an elephant in the room. You and I spoke quite a bit about it. And there's always an explanation. That was a little more complicated than I thought, and we're not going to go in and dissect it again. But I think it's important. I also think it gives you a unique perspective, if you're sent to the bench, of how, not just how, what your job is and what it means, and the consequences of words. Words do have consequences, and writings have consequences. So I'm not gonna go into everything that's already been said. I do want to say congratulations on being a member of AKA. That is a great sorority. Very, very best of our Black women are in that. You are up with some of our, well, I believe Justice Budd is also a member. I mean,
she's a member of every organization.
she is. It's a little bit intimidating if you've never seen it. Yeah, great. And the reason I mention that is because to me, not just as a woman, but as a Black woman, that's where you learn to lead. That is where you train. That is where the people you sit next to, you are all sitting there because you've achieved something and you all matter and you help each other. And I really believe in that type of leadership training, for lack of a better word. I've never been in a sorority, but I went to an all-women's college, and it was a very, very different education than many of my peers had. And it's kind of inexplicable to people, but when I see something like that, for me, it matters. So thank you. Well, congratulations, not really thank you. I don't have a lot to say. I am I live in Gloucester, and we have a small community court that is literally upstairs from our police station. And in some ways, it's a little like Mayberry RFD, like you can't get away with a lot. And I mention this because you live in the same house your grandfather built. You live in your community. You will see people on the street that will be in your courtroom. I think that is so important, because I live in a community like that, and it matters. It matters a lot. And I think in communities of color, it matters even more. We had I think one of the best and brightest judicial nominees that ever sat before us. This council voted down years ago. And it's always kind of stuck in my craw, because she was somebody who lived in the community and went to church in that community and saw those gangbangers in the pews on Sunday. And you just can't quantify that. So I think it matters. I think it matters a lot, not just that you're a woman, but you're a woman of color. It is long overdue, Judge. Thank you for paving the way and keeping the path warm. 20 years is way, way, way too long. Thank you to Counselor Jacobs for having the hearing out there that she had, so the community could come and speak about you and celebrate you, but also to her for bringing Boston to the people, because it needs to be done more. You know, COVID made it a little bit hard for us to do that, but it matters. It all really, really matters. So I really don't have any questions. The things I talked to you about, you know, with the Sweeney issue, but also the civil, you know, and you and I had a much more in-depth conversation than we're going to regurgitate right here. But I have every belief that you will have yourself up to snuff and up to date on how to deal with those matters. So that's it. That's all I have to say. Thank you.
Thank you, Counselor. Counselor Kennedy.
I was with the questions. First of all, I do want to say that Counselor Jacob, very excited to chair your hearing and very, very supportive of your nomination. She was all over me all week, you know, about chairing it. I am going to touch on the Graham decision a little bit. If a Superior Court judge wrote that about me in one of my cases, I probably would have fell over when I read it. It was pretty scathing. It was pretty harsh. I don't criticize the judge for granting a new trial. I think the new trial probably should have been granted. I don't know if the decision had to go there. I can only imagine how you felt when you read it. It's pretty bad. And I think I agree with Councilor Noah. It almost cost you your judgeship, because I think that's probably why Governor Baker, knowing him, probably hesitated to pull the trigger before he left. But I'm glad that Governor Healy took another look at it. One of the things that you're going to be facing, which they're facing all of this courts and superior courts, is a lot in probate courts, a lot of pressure to move cases. Somewhere along the line, people forgot that we had a pandemic that shut the courts down for about 2 years, at least trials down for about 2 years, and that we're still catching up. And it touches on somewhat Councilor Noah was talking about is, you know, you get a case that's 3 years old, partially because of COVID, and people want to move it. They want to change the date. You got a DA standing there objecting. I'm not going to take the extreme that he's talking about in terms of his wife taking him on vacation, because Chris's wife wouldn't take him on vacation anyway. But you know, you're standing there, you know, you just jammed up. I'm sure you've been there with trial after trial and case after case, running around like a maniac. And I haven't had time to deal with this, you know, and you got to move it. What are you going to do when you have the Chief Justice, you know, reporting your numbers that aren't moving cases fast enough and putting pressure on? And she will, trust me, you're going to be hearing from her.
I think it depends on the reason
Well, how about this?
for the continuing.
How about this? I've been breaking my butt for the last 2 months trying cases. I need a break. Because I've said that.
I have friends in that same position right now, and I do believe if you've tried a case that you might not be ready to try
Right.
the next case. So a short continuance could be anything from a couple of weeks to a month. So however long it will take to make sure that the witnesses are present and ready for trial.
And it helps avoid situations like Graham, if we have time to put effort, the right effort into it. I can assure you that in the last 40 years, I've been ineffective more than once, because none of us tries a perfect case. All of us miss something, and sometimes we just blow it. Hopefully not too often, but it happens, you know, with anybody. We had a long talk on the phone. I'm really pleased you're here. I'm not making any secret about the fact I told you before I drove for you, and nothing's changed. And the vote for nomination, I think he's gonna be a terrific judge, and I think exactly what Western Mass needs.
Thank you, Counselor. Counselor Japala.
Counselor, good afternoon.
Good afternoon.
It's your day today, but I want to start by thanking the governor, lieutenant governor, and the governor's legal office, and Counselor Jacobs as well, that you're here with us today. It's exciting. And on Monday, it was my pleasure to be in Springfield for the public hearing that Counselor Jacobs hosted. And it's carried over to today, but the feeling of joy, really, that was evident from your community is very uplifting. And I heard a lot of things at that hearing on Monday about breaths of fresh air and it's about time. And I'm just really happy that we've achieved this day, because I've heard your name before. I've heard it in the past for the new administration, and I heard it when Counselor Jacobs came in, and the new administration came in as well, and it started to come up again. I listened with great interest to the conversation around the case that I'm not going to talk about. And I don't like to look backwards. However, I've seen in my brief time on the council prior to this administration, I've seen candidates of color not move on to where you are for reasons I consider dubious. I've seen excuses made for not moving people forward. And I've seen incredibly dubious candidates who are not candidates of color move forward and sit where you are. So in one sense, better late than never. In another sense, thank goodness that we have a new administration in town who are taking issues seriously and are finding qualified, experienced candidates who also will help better reflect the community that we serve in our courthouses. So I'm just really thrilled about that. And one of your witnesses, Senior Probation Officer Kennard, talked about watching Judge Page's ascent, and now watching your ascent, the difference it makes. And I think for some of us, it's difficult to appreciate the difference it makes to see representation, to see well-earned representation. And I bring this up as an extremely roundabout way to comment on something that is not about your nomination. In my professional experience working with juveniles who find themselves court involved, I know how impactful it would be for some of these kids to see themselves reflected in the courthouse from the very top. And so I'm very excited about that possibility should it come forward as well. In Worcester and Central Mass, Central and Western Mass are different places, and we can each appreciate that. Some people can't appreciate that, and that's okay. That's okay. But in Central Mass, our courthouses do not look like the communities that they serve. And I'm proud to live in Massachusetts. I'm proud of our justice system, but we have issues we need to deal with. And so when I visit our correctional facilities, and a couple weeks ago, I was able to visit a class, Emerson, part of Emerson College's degree rewarding program. It was a big class. Back when I taught high school, it would have been too big. It would have been protesting the school committee. But I was one of two white people in the room. The other person was the professor. And we lock up people in Massachusetts. We lock up minorities at an alarming rate compared to what we do with our white defendants. And so these are real issues that need to continue to be chipped away at. What I want to ask you, though, is that we heard a little bit about you starting in juvenile court. We've heard people talk about how you relate to your clients and the backgrounds that brought them to where they are. And so as we discussed on the phone, what concerns me most in our system is like what some people call the trauma to prison pipeline, where it starts at a young age. So if I went around that classroom I was in at MCI Norfolk, everyone has a story about their childhood, about unfortunate events that happened in their childhood, happened to them usually, that typically went unaddressed. So this unaddressed childhood trauma, and then they build up a juvenile record, and then their education is all messed up, and then they end up as adults, and oftentimes they end up in the court and oftentimes incarcerated. So as a judge, you wrote in your application that when you're thinking about your discretion, you'll wish to know his or her family history, educational history, employment history, mental health history, drug addiction history. How are you going to know all that as a judge?
I would expect counsel for the defendant to present that information. Sometimes probation, the record may allude to some of that information. You can tell when someone has a drug addiction by the charges that they have on their criminal history. And if I have any concerns with regards to sentencing a particular person, what I would like to do is I'll ask probation, either for some type of probation report, also the juvenile or the young adult. And in the alternative, I would ask counsel to maybe hire a psychologist or psychiatrist, ask for funds from the court. So that way we can have more in-depth look at that particular person. But with regards to sentencing, I can only sentence to the facts that are before the court. So if the person has something where he's looking at minimum mandatory sentence, I would have to impose that. But perhaps that could be tailored with regards to the end, like I said before, with probationary period and focusing probation on whatever the particular needs of that individual are.
Having been an attorney, do you find that your criminal clients are always forthcoming with you?
No, I feel that my clients tell me what I want to hear.
And so, and they're telling their attorney that, and then the attorney is telling you that. Would you ever hold an evidentiary hearing to learn more about the mitigating circumstances in someone's life before sentencing?
No, I wouldn't hold an evidentiary hearing, but I would do as I indicated to you, that I would either request a probationary report or some type of pre-sentence report, or request the defense attorney to have the client evaluated.
Okay.
Psychologists or psychiatrists pretty much can get to the bottom of any issues they may have.
When you think about mitigating factors and we think about age at time of offense, we spoke briefly on the phone about this, but of course, the extent to which the courts are accepting of contemporary science and emerging science on brain development continues to evolve. Right now, we have it up to 21, where you can't have mandatory life. My understanding of the science is that the development that the SJC has pointed to as being a mitigating factor, that the brain's not done developing, and that it keeps going. And I'm wondering, as a Superior Court Justice, if you have an argument before you that's looking at brain science and is trying to push the date, whatever the particular situation is, push the age forward in terms of it being considered mitigating, would you be bold enough to take that up and to make that determination?
That's a very interesting question. And I think on that particular issue, I might want to have an evidentiary hearing. But again, I'd have to look at the charge that's before me, the facts that are before me, so I can't, also what the person is convicted of too.
There's a lot of variables.
I can't commit to anything, or nor will I, but I
We don't know if it'll ever come before you.
evidentiary hearing.
Okay, because likewise, the childhood trauma delays brain development as well.
I agree.
I really appreciated our conversation. Again, the outpouring of support from the community was very compelling. And I look forward to voting for you when we hold our assembly.
Thank you.
Thank you, Council.
Thank you, Counselor. So with that, I will close by echoing some of what's been said before and sharing some of the outpouring of support I've heard and received. I do want to start again by saying how much I appreciate Governor Healy for giving, first of all, her first nomination in Western Massachusetts. I really appreciate the recognition, the acknowledgement of our needs and not just for making a nomination, but one that is just so exciting for me, that has resonated with the community in such a powerful way. Your nomination has been alluded to, it's historic, and it embodies all the elements and criteria that I very much so wanted to see represented on the bench, and I know that is shared in the community as well. To quote a letter that I have submitted into record, that was penned by 12 sitting and retired justices in support of Attorney Duncan's nomination. This is in the middle of the letter, and I have shared it with the council for you to read yourselves, but I just wanted to read this paragraph, which sums up what I wanted to say so much better than I would have said it. We begin by underscoring the historical magnitude of this appointment. The Superior Court, created by Act of the General Court on November 25th, 1692, is the oldest common law trial court of continuous existence in the Western Hemisphere. Should Ms. Duncan be appointed and confirmed, she will serve as just the second non-white Western Massachusetts justice in the Superior Court's 330-year existence. During our Superior Court's first 306 years, from 1692 to 1998, no governor appointed a single African-American or non-white Superior Court judge to sit in Western Massachusetts. Then, in 1999, Governor Paul Cellucci made history by appointing the first African-American to preside here, the Honorable Tina S. Page, who served with distinction on our Superior Court until her mandatory retirement in 2020. In the 23 years since Judge Page's appointment, no Western Massachusetts African-American or non-white judge has been appointed to sit on the Superior Court in our 4 Western counties. In addition to that letter, which I've just quoted, there has been an outpouring of support in the form of calls, written submissions, and public testimony at an enormously well-attended local hearing in Springfield on Monday that has underscored the enthusiasm and respect that Attorney Duncan has engendered. I've submitted to the council the letters and written testimony I've received in support of Attorney Duncan's nomination. First, the letter I just quoted from, which is signed by 12 justices who I will name into the record. The sitting justices at the time the letter was written, the Honorable Richard Carey, the Honorable Mark Mason, the Honorable Karen Goodwin, the Honorable David Hodge, the Honorable Edward McDonough, the Honorable James Minitzis, and retired justices, the Honorable Tina Page, the Honorable Daniel Ford, the Honorable Mary Lou Rupp, the Honorable John Ferrara, the Honorable Bertha Josephson, and the Honorable Peter Vilas. Additionally, I have submitted written testimony received from Attorney Joseph Smith, Attorney Joseph Franco, Attorney Jacqueline Lee Washington, Carmen Alexander, Andrea Baker, Attorney Petra Cervoni, and the Honorable Charles Gross, Springfield District Court Justice. Further, Monday evening, October 16th, as mentioned earlier, I held an informal public hearing in Springfield to allow for an inclusive local forum for those who wish to share their testimony in support or opposition to Tracy Duncan's nomination. We had a large turnout with 7 witnesses speaking on Attorney Duncan's behalf and another 6 members of the public offering their testimony. And I've shared a report detailing what was said by those offering testimony to the council for your consideration. In very brief summary of what was said, the hearing in Springfield was an outpouring of support, respect, and love for Attorney Duncan, and a sense of excitement for a nominee who is of and from the community, has done so much good work in the community, has earned the respect of both the legal and broader Springfield community, and will do so much to restore confidence, trust, and faith in our justice system, both for who she is and what she represents. This is my first hearing for my district, and I'm so happy that you are my first nominee. You represent all that I hope to see added to the bench. And I want to let you know that when the council meets at its formal meeting, hopefully next Wednesday, that I will be more than happy to submit your name for the council for confirmation of the public hearing. Yeah, yes. So before I close the hearing, we've asked a lot, but if there's anything else you want to share with us that we haven't asked that you want us to know, I wanted to give you the floor.
Thank you for hosting me today.
Can I just add one thing that hasn't been said? This nominee not only is so qualified, but she has the life experience that she's bringing to the court, and she has the age experience. And you know, when you get someone 40 years old, they don't do what she does. They don't do the pro bono. They don't reach out to people who can't afford a lawyer. So that wasn't said here today. So there's something to be said. Don't make me cry. I just wanted to add that.
Well, with that, I will adjourn this hearing today and so pleased to have it. Thank you all. Thank you, counselors. Oh, and